اور ایج کو پڑھ لیں. جی اور ایج وہ ڈٹرمائن کرتے ہیں کہ کورٹ آف لا سے جب اس کو کوئی ڈکلریشن ہو, یہ اس ڈکلریشن کی بات ہو رہی ہے, آئی تھنک سو.
جی
آئیے اس پہ بات کریں کہ یہ 62(1)(f کہاں پہ پاور دیتے ہیں کہ آپ اتنے ٹائم کے لیے ڈسکوالیفائی ہو, اتنے ٹائم کے لیے. وہ تو صرف یہ بتاتے ہیں کوئی شخص پیپر سبمٹ ہو رہے ہیں اس سے پہلے بتا دیا کہ یہ فلاں کورٹ سے اس کو سزا ہوئی لہذا پیپر خارج, دیٹس آل, میٹر اینڈز. The authority dealing with this matter have no power to decide the disqualification period of that person. وہ disqualification کے period تو 63 نے بتا دیا, یہ سزا جرم کرو گے تو اتنی سزا ہوگی, اور اس جرم کی سزا پوری ہونے کے 2 سال بعد جب آپ نکلیں گے تو پھر آپ کوالیفائی ہوں گے. تو یہ آپ جو پہلا سوال جو آپ سے کیا کہ ڈفرنس, آپ ڈفرنس جب بتائیں گے تو خود بخود پتہ چلے گا what is 62 and what is 63.
So if 62(1)(f is juxtaposed with 63(1)(h,
H moral turpitude
ہے because وہ اس کے ساتھ dishonesty etc وہ اس کے ساتھ ہے, moral turpitude being very broad, اور وہ examine ہوا similar belief, اس کو اگر آپ سامنے رکھیں تو the consequence then, if they are to be reconciled, then the consequence is only one, which is that the timeline which is provided for the declaration in 63(1)(h must necessarily apply to the time to
فرق یہ ہو گیا نا کہ ایج میں اگر conviction ہو گئی because it attracted an offense and so it led to conviction, then he can come back. But if it was lesser than even a case where it could constitute an offense and so he could not be taken in a criminal case, a simple declaration was given on the civil side, that goes on unlimited. اب یہی سمجھ نہیں آتی because otherwise then we also have to stay away from the concept of reading into the constitution.
But now that you have started reading in, so I was just
that is also a question.
So you must stop from reading furthermore.
Reading in
just another aspect if you can attend to. Can you read D,
my lord,
again?
He is of good character and is not commonly known as one who violates Islamic injunctions.
Now please read F.
He is sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law.
Now, what does this mean? There being no declaration to the contrary by a court of law. In clause D and in clause E and in clause G, these words are not mentioned.
That's right.
So either you say clause D, E and G are redundant, they're meaningless clauses, because the words there being no declaration, either the same wording should have been followed. And I can't, at least I cannot understand the difference between good character and sagacious. I mean, good character is something different from sagacious. Is good character different from being righteous? Non-profligate. What does that even mean? What does non-profligate mean? What does it mean?
Who doesn't spend wastefully.
Israf.
Yeah.
So good character.
Yeah.
So if you are doing wazoo and wasting water, you become a profligate. Because there's a hadith of the Prophet.
That's right.
Do not waste water, and even if you're standing next to a flowing river. So then he's a profligate. So, and then we go honest. Good character, every good character person is an honest person, I would imagine. And Ameen. I mean, these are words which a Muslim would never even dare utter in deference to the Holy Prophet, that only he is and none of us are. I mean, that is humility and abject humility. You will never say that. Otherwise, why would you seek forgiveness for whenever someone dies, please forgive his sins? Do we ever say he's entitled to Jannat and Allah Ta'ala grant him Jannat? He never committed a sin. We don't even pray that for ourselves. No honest person will say any of these things, that he's sagacious, righteous, non-profligate. Even the greatest saints in Islam were scared when they were dying, that they were scared of death because they were apprehensive of what may they be meeting in the hereafter. So I don't know, is this generally a wish list kind of situation as opposed to because otherwise everybody can, if I was filing a lamination paper and if someone says he's not of good character, I would not even challenge it. I said, I'm sure I've done something wrong in my life. Maybe I've done it wrong yesterday, so I don't know. So if you're honest and you say, right, this person is right, I am not sagacious, righteous, non-profligate, honest. I do not switch off the lights when I go out of a room. I waste electricity. I waste human resources which the Almighty provides. So where does it end then? I can bring any case into disqualify someone, and I want to save someone, I can also do the same thing.
That's why.
Should such power vest in judges who are themselves humans?
That's why
They want a greater test for parliamentarians than they have for themselves. Does this language find mention in the oath of office of a judge? That I'm not profligate? Does it mention in the recommendations of a judge? All it says you have to be 45 years of age, practicing law for 10 years.
Could be
So
profligate.
we have a lower standard than parliamentarians. Why is this language then not reflected there as well? Let's accuse ourselves before we accuse anybody else what they are or what they are not. So either we have a much lesser test, we can't, at least I would be very scared to meet this test, terrified to meet this test. So either we don't have a similar test. So we have to read the Constitution as a living whole. And where the Constitution has brought down the acts, it clearly says 2 years, 5 years, 3 years, 2 years, or it's factual, you're not a citizen, fine, that's very clear. There is no punishment here, but you're out. So without a punishment, you're out. There's no punishment. So, but suppose a person is a citizen of Pakistan, not a Pakistani citizen, but becomes a citizen of Pakistan later. Would he stand disqualified for life? Suppose he filed a nomination paper and he had another nationality or whatever, and he got disqualified. Is it disqualification for life? And then subsequently he said, okay, I've surrendered my US nationality and now I want to contest. So I don't know, we have to read it in a way that is meaningful. And we must bear in mind the conditionalities that were imposed to exclude people from this. I mean, the degree situation. Thankfully, it wasn't there when the Qaid was around, because he would have been disqualified.
That's right.
He wasn't a graduate.
ये amendment कब हुई? ये amendment
2002 की 8 की
2002 में
किसने की amendment?
This was
presidential order.
क्या वो president खुद इन पे उतर सकता था, इन तमाम requirement पूरी कर सकता?
But ये general military general ज़ियाउल हक
नहीं
की
होते, बाद में डिग्रीज करते हैं, शुरू में नहीं होते.
नॉन इलेक्टेड मेंबर्स अगर अमेंडमेंट करेंगे तो यही होगा.
Mr. Attorney General, the question is that while we're looking at D, E and G, which to my mind appears to be a guideline for the voters, the actual gatekeepers, and they might keep this in mind when they're voting because nobody can execute them and put anybody behind anything. So D, E and G to sir guideline ho sakti hai voters ke liye, and that's never been agitated. The $1 million question is, how do we look at the line, no declaration to the contrary by a court of law? What do we do with this? I mean, this is in the Constitution.
If I may,
I think my lords have raised the questions. Can we read the law on declarations? What is the law on declarations? Section 42 of the
Section 42 of the Special Relief Act.
I would imagine, is that the only declaration that has been indicated here?
There's no other declaration. और तो कोई है ही नहीं.
कोई और law होता है declarations का? Specific Relief Act.
Only Special Relief Act, Section 42. Legal character के ऊपर जो है ना, वो that is the only law.
Declaratory suits are filed under 62 one है.
हो नहीं
Section 42.
Constitution में रहा. ये तो
इन्होंने कर दिया ना, बट अगर कोई चैलेंज करेगा तो वो तो 42 में ही करेगा. नेगेटिव डिक्लेरेशन.
Negative declaration concept है ना. Positive declaration is not negative declaration. We have held in paternity cases that you cannot do negative declarations.
paternity can
किया ना, negative positive.
negative कर सकते हैं paternity.
Negative positive, हाँ. Negative नहीं हो सकता है क्या?
Person entitled to any character right of any property.
दे देना इनको specific relief act सर. आप अटर्नी जनरल को दे देना.
कह सकता हूँ कि हम honest.
यही दे देना प्लीज.
ये मैं दावा फाइल कर सकता हूँ कि झूठा नहीं, मैं honest.
Yes. Ji.
So that's it.
Ji, sir. I have it before me. Mr. Jilani's iPad is very helpful. Discretion of court as to declaration of status or right. Any any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Bar to such declaration, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so.
By the court, to what is understood by court? A civil court?
Yes.
Under Section 9, or is it a constitutional court?
Now, this is it's a civil court where evidence can be led, witnesses can be examined, where a burden of proof is discharged, and then there is an opportunity of rebuttal.
Suppose in a case where I've done so even, we observe hearing a civil petition for leave to appeal or an appeal that the appellant had dishonestly filed a suit. Suppose we hold that, and we've held so, and impose costs on him. Will that constitute a declaration of a court of law in terms of Article 62(1)(f)?
My respectful submission is no, sir.
Why?
Because you are not a court where that particular issue is actually conclusively determined through a trial.
So we could observe in other cases. We could say in a criminal case that I don't believe this witness is a liar. And that witness will then be struck by 62(1)(f) because it's a declaration of a court of law. And in a judgment in a criminal case, he was not an accused there, but he was a witness. And the court says, I don't trust this witness. I found him to lie.
My lord,
so it's, then you can bring out every case. We may make an observation against a lawyer. He misled the court, for instance. Sometimes we do that.
My lord,
regretfully. And then if a lawyer contests election, the person will say, you have held that he misled the court. He is, of course, how can you allow him now to contest an election? He's banned for life.
My lord, now...
जी साहब एक चीज और देख लीजिए, डिक्लेरेटरी जजमेंट्स का जो सुप्रीम कोर्ट के लिए प्रोवाइडेड है ना, वो आर्टिकल 184 सब आर्टिकल 1 में है। वो डिक्लेरेटरी जजमेंट्स हैं सूबे और वफाक के दरमियान जो झगड़े होते हैं ना, उसमें लिखा हुआ है कि सुप्रीम कोर्ट शैल प्रोनाउंस डिक्लेरेटरी जजमेंट। उसके अलावा के डिक्लेरेटरी जजमेंट 184 and 185 में लिखा हुआ है।
No, 184.3 is not mere declaration. I mean, 184.3, the court goes on to conduct...
शिजाज शौकत साहब यहाँ बैठे हैं जो सिविल कोर्ट के माहिर हैं, तो आप बताइए ना ये वाली डिक्लेरेशन कैसे होगी?
दो चीजें ऐड कर दूं,
बता दें।
आप सपोर्ट कर रहे हैं लॉ को या अपोज कर रहे हैं लॉ को?
I am supporting the law.
The law.
I am against.
We want to hear from those who are opposing the law.
There's none.
So then
there is somebody who said yes.
Then hear him out.
I am opposing this.
So, yeah, I think in the course of proceedings...
Let's hear the challenge. I just want to understand how the opposition is.
That's right.
जी बताइए।
My lord, आप अपोज कर रहे हैं तो पहले ये बताइए कि इसको चैलेंज किया है।
मैं लॉ को इस बारे में अपोज कर रहा हूँ।
नहीं, पहले बताइए कि अगर है तो हाई कोर्ट में चैलेंज किया वारिस को इसकी आपने?
मैंने तो चैलेंज नहीं किया।
तो फिर अब क्या अपोज करेंगे आप?
गुजारिश ये मालूम, क्योंकि समीउल्लाह बलोच केस अगर मौजूद है जो कि कॉन्स्टिट्यूशन कर रहा है,
माइक अपने सामने,
इसीलिए तो आपसे पूछा ना, समीउल्लाह बलोच है, उसके बाद आप समझते हैं कि लॉ गलत अमेंड हुआ है, 232 गलत आ गया है, तो वेदर यू हैव चैलेंज द वायरीज इन द हाई कोर्ट और नॉट?
That can be challenged before this proceeding, my lord, because that question is just alive before the honorable and the same notice administration on that question. And in this proceeding, this honorable court has every authority to declare the law which has been passed in violating the provision of the constitution or whereby.
But अभी उस्मान आपने कहा था कि are you supporting life disqualification or?
I'm
सर मैंने कहा था कि
नहीं उस्मान ने क्या कहा था?
मैंने ये कहा है मालूम कि जब तक समीउल्लाह बलोच मौजूद है ये लॉ नहीं आ सकता, ये लॉ अल्ट्रा वाइड।
मेन केस में आपकी क्या है कि डिस्क्वालिफिकेशन लाइफ को आप सपोर्ट करते हैं या नहीं?
मैं डिस्क्वालिफिकेशन को असिस्ट मैं इस पॉइंट पे करना चाहता हूं कि रीविजिट हो सकता है कानून, लेकिन वो इन कंडीशंस के साथ रीविजिट हो सकता है। وہ میں
ایک دیکھیں وضاحت سے بات کیجئے نا, گول شول باتیں نہ کیجئے نا. آپ لائیو ڈسکوالیفیکیشن کے فیور میں یا خلاف ہیں؟ سیدھی بات
میں
کریں.
لائیو ڈسکوالیفیکیشن کی فیور میں اس حد تک ہوں کہ اگر سمیع اللہ بلوچ پرویل کرتا ہے,
آپ سے سیدھی
اگر
بات
نہیں
پوچھ رہے
پرویل
ہیں
کرتا,
ہم یہ کیا سوال جواب دے رہے ہیں آپ؟
نہیں, either you support the principle or not.
لا کو سپورٹ میں اس لیے نہیں کر سکتا کہ لا اگینسٹ دی ججمنٹ آف دی سپریم کورٹ ہے.
اگر against the judgment ہے,
انٹرپریٹیشن ری انٹرپریٹ ہو سکتی ہے پروویژن.
سپریم کورٹ کا ججمنٹ جب تک تھا اس کے بعد پارلیمنٹ نے لا امینڈ کیا. اگر آپ یہ کہہ رہے ہیں اس کا مطلب ہے کہ سپریم کورٹ کی ججمنٹ کے بعد پارلیمنٹ لا نہیں بنا سکتا.
لا بنا سکتی ہے اسٹیچوری انٹرپریٹیشن کے بارے میں, جہاں اسٹیچوٹ انٹرپریٹ ہوا.
چلے لا کا تو ٹھیک ہو گیا, but are you saying that the principle settled in Sami'ullah Baloch, you agree with it?
No, that I don't agree. I want to say that there is some conditions for the on the basis of state decisive principle کہ کب وہ ججمنٹ جو ہے وہ ریوزٹ ہو سکتی ہے اور کیا وہ conditions.
آپ بار بار وہی چیز ریپیٹ نہ کریں نا, اب آپ سیدھی بات ہم سے کر نہیں رہے ہیں. ججمنٹ کو چھوڑ دیجئے 2 منٹ کے لیے, لا کو بھی چھوڑ دیجئے, ہم صرف آپ کی رائے معلوم کرنا چاہ رہے ہیں. آپ لائف ٹائم ڈسکوالیفیکیشن کو 62(1)(f سپورٹ کر رہے ہیں یا نہیں کر رہے ہیں؟ کچھ ہاں یا نہ تو کر رہے ہیں.
میں نہیں سپورٹ کر رہا,
نہیں کر رہے ہیں. اچھا, ہم سننا چاہتے ہیں کہ کون سپورٹ کر رہا ہے. ایک سیکنڈ ٹھہر جائے, ہم کو سنیں گے آپ کی وقت پہ. قانونی بات کریں گے تو کریے, آ جائیں بتائیے. ایک سیکنڈ, لیٹ اس ہیئر مسٹر سمیع اللہ بلوچ, the person himself.
جی,
ثناء اللہ بلوچ.
بسم اللہ الرحمن الرحیم. شکریہ معزز جج صاحبان.
یہ آپ کا یہ کیس ہے؟
جی سر, یہ میرا یہ کیس ہے.
یہ تو لکھا ہے سمیع اللہ بلوچ.
Sir, Sami'ullah Baloch is my brother, and Abdul Karim Noshrawani, I am the aggrieved person because I contested the election against
تو سمیع اللہ بلوچ کہاں ہیں؟
Abdul Karim Noshrawani. Sir, he is my brother because the case is mine. So,
آپ ان کے اٹرنی ہیں, آپ کیسے آپ پیش ہوئے تھے؟
جی ہاں, میں پیش ہوں سر, بیکاز میں ایگریوڈ پارٹی ہوں. جو میں نے 2002 کے بعد جب الیکشنز ہوئے, میں اس کی تفصیلات میں بات
تفصیل نہ بتا دیں نا, آپ بتا دیں کس گراؤنڈ پہ آپ کرنا چاہتے ہیں.
میں گراؤنڈ پہ سر, گراؤنڈ یہ ہے کہ جو کانسٹیٹیوشنل جو پرنسپلز ہیں اس کے تحت سپریم جو جوڈیشل سپریمیسی ہے اس کو مد نظر رکھتے ہوئے
یہ ایسی باتیں نہ کریں عدالت میں. جوڈیشل سپریمیسی کیا چیز ہوتی ہے؟
میں سر اگر آپ کی
نہیں ایسی باتیں نہ کریں ہم سے. کانسٹیٹیوشنل سپریمیسی کی بات سنی تھی ہم نے, اب آپ جوڈیشل سپریمیسی کا میں نے کانسیپٹ نہیں سنا ہے.
سر یہ جو
نہیں دیکھیے قانونی بات کریں نا, یہ ایسی باتیں نہ کریں.
سر یہ جو آرٹیکل 62 اور 63 ہے, یہ کانسٹیٹیوشن میں گزشتہ 50 سال سے اور بالخصوص 18ویں ترمیم کے بعد اس میں کچھ ترامیم ہوئی, لیکن پرٹیکولرلی 62(1)(f) میں ترامیم نہیں کی گئی. یہ ٹوٹل 5 صفحات پر مشتمل کانسٹیٹیوشن کے اندر بہت کلیئرلی انٹری اور ایگزٹ پوائنٹس دیے گئے ہیں حق کے نمائندگی کے لیے, اختیارات کے لیے. کہنے کا مقصد یہ ہے کہ سر جب یہ 2013 کے بعد سے جب یہ,
اگر آپ کہہ رہے ہیں نا 50 سال سے یہ اسٹیچوٹ بکس پہ ہے, تو پہلے کیوں نہیں کبھی کوئی ڈسکوالیفائی ہوا؟
میں اس پہ آ رہا ہوں سر. بات یہ ہے کہ سر یہ جو ہے 2002 کے بعد سے زیر بحث آیا. یہ 20 سال سے سر سپریم کورٹ اور بلوچستان ہائی کورٹ اور دیگر کورٹس میں یہ تفصیل کے ساتھ یہ زیر بحث رہا ہے موضوع, اور اس میں 62 اور 63 کی بہت کلیئرلی کیئرفلی میٹیکولسلی جو ہے سر اس کی تشریح کی گئی ہے مختلف کیسز میں.
میٹیکولسلی ایسے تو نہ باتیں کریں نا
سر, میں
پوائنٹ پہ آ جائیں.
پوائنٹ پہ آتا ہوں. تو سر جب ایک کانسٹیٹیوشن کے اندر جب 63 کی جب بات کی جا رہی ہے کہ وہاں 5 سال کا تعین کیا گیا ہے, کیوں 62(1)(f) میں نہیں کیا گیا؟ اس کی بنیادی وجہ یہ ہے سر, جب میں ایز اے ممبر پارلیمنٹ میں جاتا ہوں, جب ڈکلیریشن دیتا ہوں, وہ اوتھ ہے. میں اوتھ میں یہ کہتا ہوں کہ میں شہری ہوں, میں نے BA پاس کیا ہے, میری عمر 25 سال ہے. یہ جب میرے خلاف جس شخص نے کنٹیسٹ کیا تھا, جب میں نے اس کو کنٹیسٹ کیا کورٹ میں, اس کی عمر 24 سال تھی. الیکشن میں کیونکہ اس کے پاس والد کے پاس BA کی کوالیفیکیشن نہیں تھی, تو اس کا کیا ہوا کہ اس میں 5-6 مس ریپرزنٹیشنز کی, اس میں فراڈری کی, اور جو ڈگری ہے.
فیکٹس پہ نہ جائیں نا, اب یہ بتائیں جلدی بتا دیں.
اس جگہ ہی سوال ہے آپ سے. آپ یہ کہہ رہے ہیں نا کہ یہ جو ڈیکلیریشن جو ہمیں سمجھ نہیں آ رہی سچویشن کی, وہ یہ ہے کہ میکسیمم جھوٹ بولا نا, اس نے فارم میں جھوٹ بول دیا, مس ڈیکلیریشن کر, تو جھوٹ کی سزا یہ ہے کہ وہ ساری عمر کے لیے الیکشن پروسیس سے آؤٹ ہو گیا. یہ لکھا ہوا ہے آئین. دوسری طرف ہم پڑھتے ہیں تو اگر قتل بھی کر دیا, ٹریزن بھی کر دیا, تو پھر بھی کچھ کچھ ٹائم گزرے گا تو واپس آ سکتا ہے. یہ بات ریکنسائل نہیں ہو رہی ہے.
سر یہ جو کیس آپ کا سمیع اللہ بلوچ
آپ اپنا بتائیں.
میں اپنا بتا رہا ہوں سر.
میں آپ کو آپ کیس کو 1 منٹ رہنے دیں, آپ اپنا ویو بتائیں.
میرا ویو یہ ہے سر
بینگ اے پولیٹیشین آپ بتائیں
کہ 63 کے بعد جب کسی شخص کو سزا ہوتا ہے تو وہ ایک اسٹیگما ہے, اس کے ماتھے پہ ایک داغ لگ جاتا ہے, وہ 2 سے 4 سال قید کا گزارتا ہے, پورے معاشرے میں اس کی فیملی سفر کرتی ہے, فائنینشیل سفر کرتا ہے, مورلی سفر کرتا ہے, اس کی جاری سوسائٹی میں اس کی اہمیت اور حیثیت کم ہو جاتی ہے. اس کے بعد جب وہ نکلتا ہے تو اس کے بعد اجازت ہے کہ 5 سال کے بعد وہ جائے, اگر اس کے پاس گنجائش ہے وہ ہم کے پاس جائے. لیکن اس میں سر جب آپ انٹری پوائنٹ پہ جھوٹ بولتے ہیں, جب آپ داخلے کے وقت
جیسے آپ نے کہا, دیکھیں ایک پوائنٹ لیتے ہیں, 24 سال کا تھا, آپ نے کہا کہ اس وقت وہ 25 سال کا نہیں تھا. 24 سال کا تو صرف ایک ہی پوائنٹ ہوتا, اس کے ڈیکلریشن پہ آپ نے اس کو چیلنج کر دیا, وہ پروو ہو گیا کہ 24 سال کا ہے. آپ کی رائے میں وہ فار لائف ڈسکوالیفائی ہو جائے گا, پھر وہ الیکشن کنٹیسٹ نہیں کر سکتا. Is it your point?
With your honorable permission, sir, اب وجہ کیا ہوئی اس وقت؟ یہ میری وجہ ہے,
یہی پوائنٹ ہے آپ.
سر میری یہ پوائنٹ اس وقت اس لیے سنی جب نہیں گئی, وہ شخص داخل ہو گیا, اس نے بیریئر کراس کر لیا, وہ جھوٹ کے باوجود وہ بلوچستان میں وزیر داخلہ بنا, جو ابھی اس سے پہلے کیس.
پھر ذاتیات پہ نہ جائیے.
نہیں سر,
ہم ذاتیات کو چھوڑ دیجئے, ہم آئینی نقطے کی بات کر رہے ہیں. ہو سکتا ہے بہت برا آدمی ہے, ہم اس میں نہیں جانا چاہتے, تو آپ ذاتیات کو چھوڑ دیجئے, آئین کی بات کریں. آپ پارلیمنٹیرین ہیں نا, ہم ذاتیات پہ بہت سکتا ہے اچھا آدمی برا آدمی, وہ ہمارے سامنے بحث نہیں ہم نے کریں گے, کیونکہ ہم ایک جنرل پرنسپل تعین کرنا چاہ رہے ہیں.
اب ثناء اللہ بلوچ صاحب دیکھیں, میں آپ کو بتا جو ہمارے لیے کمپیریزن میں پرابلم آ رہی ہے نا, ایک طرف 63A میں آپ جتنا مرضی کرائم کر دیں, آپ کچھ عرصہ سزا کاٹیں, 5 سال گزاریں تو واپس آ جائیں. ہمیں یہ پرابلم ہو رہی ہے کہ سول ڈیکلیریشن میں سزا نہیں ہے, کوئی سزا تو اس نے نہیں کاٹنی, سوائے یہ سزا اس نے کاٹی کہ وہ والا الیکشن مس ہو گیا اس کا. اگلے الیکشن میں تو وہ آ سکے نا. اب یہ کہنا کہ اگلے الیکشن میں بھی نہیں آئے گا, کبھی بھی نہیں آئے گا, یہ ہمیں سمجھ نہیں آ رہی کہ سول اس نے جھوٹ بولا, جھوٹ کی سزا آپ نے دی کہ تم اس نامینیشن پیپر ریجیکٹ ہو گئے تمہارے, تم نے الیکشن نہیں لڑا, سزا مل گئی نا. جو کرمنل سائٹ پہ اس کو ویسے سزا مل رہی, سول سائٹ پہ یہ سزا ہو گئی. اب آگے چلے نا, اب وہ کیا اس نے ایک جھوٹ بول دیا, مس ڈیکلیریشن کر دی, اب وہ ساری عمر کیسے. دوسری طرف پھر تو ہونا آئین میں ہر جگہ لمیٹیشن ہے, ٹائم کی سٹوری ہے ہر جگہ, تو پھر اس جگہ بھی تو کچھ ہونی چاہیے نا. عجیب لگا.
میں اس حق میں ہوں کہ 232 ابھی جو جھوٹ,
میں اس حق کی بات چھوڑ دیں نا. اگر دیکھیں, اچھا ایکچولی آئی ایم اسپاٹنگ از دیٹ مختوم علی خان, کین وی ریکویسٹ یو ٹو, since Mr. Makhdoom Ali Khan has written on the Constitution, I don't know if he's involved in any case before us. Are you in these matters? Huh?
Yes. My lord.
Which case are you in?
I have filed a CMA 6 of 2024.
For whom? In favor of disqualification or lifetime or not?
My lord, not in favor.
But you're not in, why, who have you filed it for?
For Mr. Jahangir Khan Tareen, my lord.
Okay. Now, one thing which nobody has attended to yet, at least one way of interpreting the Constitution is what the original Constitution said. And this Constitution has been, I don't know what's the correct word, changed or ravaged from time to time, what you want to use it. Can we read the original Constitution as it was enacted in 1973?
My lord.
And see what the Constitution then said.
My lord, I will read that provision to your lordship.
Would you like to do it, or should we ask the Attorney General to do so?
As your lordship pleases, the history is...
No, we were thinking of appointing you as a Michaels, but you are representing a party, so anyways, let's...
As your lordship.
Nahi, padhe 62. Do you have the original Constitution?
Yes, my lord, I have, and the history is traced in Samiullah Baloch.
No, we want to read the actual text.
Yes, my lord. The text is there.
85.
Ye de de inko. وہ دے دیں ان کو.
Yeah, we have it, my lord.
Qualifications for membership of parliament.
Can you come to one of the other mic?
My lord,
benefit of...
My lord, Article 62, there used to be only 3 qualifications. One, he is a citizen of Pakistan.
Read the whole article.
My lord, a person shall not be qualified to be elected or chosen as a member of parliament unless he is a citizen of Pakistan. B, is in the case of the National Assembly not less than 25 years of age and is enrolled as a voter in any electoral roll for the election to that assembly. C, C, he's in the case of the Senate, not less than 30 years of age and is enrolled as a voter in any area in a province, or as the case may be, the federal capital or the federally administered tribal areas from where he seeks membership. And D, he possesses such other qualifications as may be prescribed by Act of Parliament.
So these troublesome provisions were not there.
No, my lord.
When did they come into?
My lord, by Presidential Order number 14 of 1985, which is also called the Revival of the Constitution Order.
This is General Zia.
General Zia, when the martial law was coming to an end and partyless elections were soon to
Is it ironic that a person who violates the constitution of the country puts in these conditions? I find that a bit troublesome, isn't it?
Yes, he after D.
Was he of good character? If he violates the oath that he took to uphold and protect the Constitution, and he destroys the Constitution, it's very ironic for me that he inserts a good character, knowledge of Islamic teachings. I wonder which knowledge of Islamic teaching mandates judges to be sent home because they don't swear an oath of fealty to the martial law administrator. What is your view on that?
My lord, these are, with great respect, all these provisions which have been added by the RCO or the Presidential Order 14.
Was he non-profligate?
My lord, these are matters which I would say...
Yeah, we want your answer on this.
My lord, these are matters for divine judgment. These are matters for divine judgment.
You mean to say matter of treason is for divine judgment?
My lord, no. And treason is not an issue, but if we come to treason, then in person,
martial law is admitted?
Yes. If it comes to an act of treason, then in that particular case...
Do you think he committed treason or not?
My lord, in your lordship is talking of 1977.
You're talking about, yes.
Your lordship will then have to examine it.
You know, we are asking your opinion.
My lord, I would be bound by the judgment of this honorable
court. We are asking your opinion.
My opinion is different, but the judgment of this honorable...
Share your opinion with us.
The judgment of this honorable court in Begum Nusrat Bhutto's case takes a different view.
चले आप नहीं बताना चाहते रहने दें फिर.
My lord, my view...
चले बाकी पढ़ लेते 63. तो ये D तक था. There was no present D, present E, present F and present G.
Yes, my lord. The D...
and 63 was also pretty succinct.
Yes, it was, my lord. 63 was also very limited.
कैसे उसमें हम पढ़ लें टाइम यही समय बात है ये सारे नहीं ला सकते ना
My lord, 63, a person shall be disqualified from being elected or chosen as and from being a member of parliament if A, he is of unsound mind and has been so declared by a competent court, or B, he is an undischarged insolvent, or C, he ceases to be a citizen of Pakistan or requires the citizenship of a foreign state, or D, he holds any office of profit in the service of Pakistan other than an office declared by law not to disqualify its holder, or E, if he is so disqualified by Act of Parliament.
So it was pretty straightforward and simple.
It was.
And RCO kind of molded the constitution.
Yes. RCO changed it in two respects. It brought in these qualifications and added a whole host of disqualifications as well.
By a person who was of sagacious, righteous, non-profligate, honest and good character.
Yes.
Yes.
But the point is 18th Amendment stamped on it. You see,
my lord, 8th Amendment stamped on it.
No, देखिए,
and then 18th Amendment.
Mr. Makhdoom Ali Khan, at least now I will speak for myself. I don't know. Wherever this is one way of interpreting the Constitution, and I've held it in a judgment or two, that wherever there is problem areas or difference of opinion or two interpretations possible, at least I've chosen the one interpretation which found mentioned in the original pristine constitution chosen by the directly elected representatives of the people and not martial law administrators. Why are you so scared of martial law administrators to utter these words, Mr. Makhdoom Ali Khan?
My lord, may I submit that this is also the jurisprudence of this court In Al-Jihad case, Mr. Justice Ajmal Mia took the view that if there is a conflict or tension between two provisions of the Constitution, one which was enacted at a time when the Constitution was in abeyance and other at the time when the Constitution was in full force, it is the latter which will then prevail, and that view has been reiterated in Samiullah Baloch, though the principles drawn from it thereafter are different. So what your lordship is observing.
So where is it mentioned in Samiullah Baloch?
My lord, in the Samiullah Baloch case itself.
No, I just want to read that part.
Yes, my lord. Your lordship will see the constitutional principle is identified in the Samiullah Baloch case itself at page 435. Page 435.
At this point that you are saying.
Yes, yes, my lord. This point is there on page 435. This is PLD 2018, Supreme Court 405.
Which paragraph are you reading?
Paragraph 22.
G.
If your lordship will see, there are a number of judgments cited, and then it says reference by the President, PLD 1957, Supreme Court 219 at 235. As such, the Constitution must be interpreted as a whole because it is an organic document that is meant to apply to the changing circumstances of time and space. Consequently, each provision of Constitution or part thereof has purpose, meaning, and integral place that must be understood, acknowledged, and applied harmoniously. It is only when a conflict between two provisions of the Constitution is irreconcilable and one of such provisions was inserted when the Constitution was held in abeyance, then the provision which was made part of the Constitution during the period of its abeyance would yield.
But would it apply because it after the 18th Amendment having stamping it, so it's not really, that was a democratic dispensation at that time.
My lord, it was, but your lordships prior to this also in Al-Jihad's case took the view that in spite of the fact that whatever General Zia had done had been validated to a large extent by the 8th Amendment to the Constitution, this Honorable Court took the view that, and that was in particular, my lord, in relation to a provision where a judge of the High Court declined to go to the Federal Shariat Court and was as a result sent home. Their lordships took the view, particularly Mr. Justice Ajmal Mia, that this provision was inserted at a time when the country was going through a period of constitutional abeyance. No doubt it was validated by the 8th Amendment, but when we examine it and juxtapose it with other provisions relating to judiciary, this having been added at the time cannot be allowed to hold sway, and that is why their lordships held that a judge of the High Court cannot be sent to the Federal Shariat Court against his will, and if he refuses, will not cease to hold the office of a judge of the High Court. So, in spite of that, this has been the jurisprudence of this Honorable Court, that in spite of the validation.
Mr. Makhdoom Ali Khan, but would you put validation at par with an original enactment which has been thought about, carefully considered by every member of Parliament? A validation was also a bitter pill for the parliamentarians to swallow. If you don't validate, I continue. So it may be that, okay, we are getting something, is better than nothing, let's at least get on with it. But we are now faced with a problem. So simple validation, when the original constitution said something else, if there are two possible ways to interpret something, and more so when what has been added is very ambiguous. I don't know why these vague words were introduced. You could have simply said A, B, C, D, like every other thing is factual. Either it's a yes or it's a no. Are you of good character? Please don't answer this question. But which person would say this? I mean, it would be a very audacious person who would say, I'm honest, Ameen, and everything. And then probably he will be making other claims which will be totally not permissible. So simple validation is a bitter pill which has been swallowed from time to time to get democracy back on the rails. Would you not agree with that, since we consider you a constitutional expert to consider validation at par with a constitutional provision, or it has to be read in the context of, because this judgment also says in space and time. The space then was a dictatorship. Either you continue another 10 years of a dictator or get some sort of a diluted form of democracy, get us back on the rails, whichever is better. So probably the parliamentarians, we should not always condemn the parliamentarians. We should see the difficult circumstances that they work under. I mean, they are, we should respect them. And what would you have done? Let's put yourself in the position of parliament, make yourself a parliamentarian then, that you would, validate something which you may not be very happy with, but at least get the business back on track. How would you personally attend to it?
My Lord, my respectful submission is that though the earlier two judgments which I have just identified by this Honorable Court do not put it in the terms that your Lordship has, but that was probably at the back of their mind when they said that an amendment made during the period of constitutional abeyance, if it is in conflict with or cannot be reconciled with the provision originally enacted in the Constitution, then the latter will prevail. So obviously this Honorable Court has not treated the validation at the same level as the original Constitution, recognizing all the difficulties which your Lordship have articulated, but not articulating them in this particular manner. Otherwise, my Lord, if any amendment made to the Constitution eventually when made stands on the same plane as any other constitutional provision, but your Lordships have held that we will distinguish between constitutional provisions made during a period of constitutional abeyance.
What's your main argument? Is this your mainstay of your argument?
My Lord, my main argument in this particular case would be that insofar as when your Lordship examines Article 62 and 63, because some of these amendments, as your Lordship has just now noticed, came in at the same time, there is a relationship between the two. And with great respect to this extent that Samiullah Baloch says that 62 and 63 have to be looked at through different lenses, it is, with great respect, incorrectly decided. Because when your Lordship looks at 62 and 63 and the amendments came about at the same time, 62F, which your Lordship is looking in particular, which says he's sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law, and your Lordship examines it with 63(1)H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. They are to be read together.
I mean, that is dependent upon 62 is dependent upon 63.
63, and I would go to the extent of saying that when your Lordship looks at G, for instance, he has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan. It has to be related to H, which says he has been on conviction for any offence involving moral.
So what does that mean? I mean, where does that leave these provisions 62?
My Lord,
what's the effect?
My submission would be that unless there is a conviction, and that would be the declaration I would be seeing, not at...
So what are these clauses? They go.
My Lord, if there is no conviction, then in the case of
D, E and G, for example.
My Lord, D and E and F probably all will have to be related to H. 63(1)H.
F actually talks about a declaration. D, E and G don't. They could be, one could argue that because there is no third party declaration, we can go into conviction area. But where do we take the declaration part?
My Lord, declaration, now if your Lordship looks at it in terms of section... One thing which immediately comes to mind is Section 42 of the Specific Relief Act, which talks about declaration of a legal character. Now, this cannot be that kind of a declaration because, as your lordships have repeatedly observed, a negative declaration is impossible to obtain. Then your lordship,
Sometimes permissible, negative declaration is permissible sometimes in some events that
Yes.
can be granted by
Yes.
the court.
there has been some revisitation or some revisitation of Alvi Sons, but otherwise that remains good law. Then if your lordship looks at 199, that also is talking of declarations being made by this honorable court, but that's in a completely different context.
That is only
Then what do you make out of this declaration for a court of law?
My lord, I would say that the term is not used specifically in the section 42 sense of the term.
Maybe it's a constitutional declaration.
It's a constitutional declaration, and that the declaration which the Constitution is envisaging is there has been a conviction already under 63(1)(h). And then there is this gateway. He cannot file his papers before the returning officer because at that time the returning officer may refuse to accept them. But the anomaly which arises when your lordship looks at 63(1)(h) in particular, and G and H both, actually, when your lordship looks at it, for instance at H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. So even a conviction which is followed by a sentence of 1 year 11 months does not lead to disqualification even of 1 day.
Enough. So that's understood.
So therefore the connection which Samiullah Baloch makes between a person being an ex-convict suffering all his life, the stigma that he's a convict, is really not what 63(1)(h) is all about. 63(1)(h) is all about sentencing. If the person has been convicted and sentenced till the rising of the court, he's not disqualified at all.
No, but there is a difference, you see, the opening paragraph of section 62 and 63.
My lord,
they need to be read and harmonized. A person shall not be qualified to be elected or chosen. And if you will read 63, a person shall be disqualified from being elected or chosen. So वो जो उसमें चीजें लिखी हैं वो आफ्टर कन्विक्शन है कि अगर कोई कन्विक्ट हो गया है, उसकी सजा खत्म हो गई है, तो इस इतने पीरियड के बाद वो इलेक्शन लड़ सकता है. To be elected and from being elected. This is the
correct. But if your lordship may graciously be pleased to look at clause 2 of 62, these words are used very loosely. The disqualifications specified in paragraph D and E doesn't talk about qualifications. Article 62.
But both are different situations.
No, my lord, Article 62, Clause 2 is talking of disqualifications under 62. It's not talking of qualifications. So this is very loose language which has been used.
Practically interchangeable.
Interchangeable language. Because
one question which I have. DE does not have the wording there being no declaration to the contrary by a court of law.
My lord, yes.
When does D, E and G kick in?
How can they ever kick in actually in any court of law? They cannot kick in.
Or they're meaningless words?
My lord,
They're just guidelines.
they are exhortatory perhaps for the guidance of the electorate that watch out for candidates.
So first of all, you are saying that they are of there are no consequences which follow with D, E and F. D, E and G.
They will, my lord, D, E.
But ideally, the same wording should have been used, there being no declaration to the contrary by a court of law in D, in E and in G.
My lord,
These wordings are only found mentioned in F.
My lord, these were added in F under the 18th amendment. These words were originally not there, and the reason for adding it appears to be, as the Attorney General identified, that under F, returning officers had started disqualifying people by saying, "आप चौथा कलमा जरा सुना दीजिए, आप चौथा कलमा जरा सुना दीजिए," इस तरह की चीजें.
They can still do that in E.
They can. They very much
That's
can.
the problem. You see, what we don't understand is D, E, G are there, and what do we? They're not executable as such. How could we? So, I mean, I myself read them as for the gatekeepers, as the voters, and maybe they keep that in mind, not vote because it's a subjective decision.
My lord, yes.
But cannot be enforced in a court of law.
My lord, that is what in the case of Ishaq Khan Khakwani, one of the learned judges, as my lord Mr. Justice Faiz Isa identified in Sheikh Rashid's case, took the view that no disqualification can really take place over here. These are very open-ended words. And your lordship points it out in your dissenting opinion in Sheikh Rashid's case, where your lordship identifies the 7 questions which are to be dealt with by the court, because that's...
But Mr. Makhdoom, the problem is that I'm facing is you can't attribute redundancy to the Constitution.
My lord, yes.
Or to any law for that matter. And then secondly, you can't read into the Constitution. So
My
the
lord.
time frame, suppose if one were to say that this F applies for that election, that particular election which the nomination papers are rejected, and it ends. Now that's not written. So how, I mean, that's the worry that I have. How do we read in a time frame into it? Either we read them with 63 and create a larger timeline concept. How does it work? Or go on the validation point.
And if I may just add what my learned brother has just said, what I've understood from your submission is what you are saying, Samiullah Baloch does not accord with the Constitution.
That's the submission.
That's your argument. Can we not say that Samiullah Baloch for its time was good, valid judgment? However, since the lacuna has now been provided by Parliament, and they've given a 5-year time limit, both can be reconciled. That was good then, and now 5 years is. If your 5 years have expired, would you agree with that, or you would not agree with that?
No, I would absolutely agree with that, my lord. My submission is that Samiullah Baloch was enacted, was decided at a time when we didn't have this newly amended law. At that time, the law did not, and there was no timeline set. The Samiullah Baloch case was decided in a particular manner. The legislature has now filled that gap. In Samiullah Baloch, it was observed that there is a declaration. Until such time that the declaration stands, then the person would remain disqualified or will not be qualified. Now the legislation says that the period of such a declaration will not go beyond 5 years.
5 years. Okay, now I will ask you the supplementary question, and I knew you would come here. Thank you. Now can I put it to you that Section 232(2) is unconstitutional? Can I put this to you or not?
My lord, that is a very valid question. Of course, your lordship can put any question.
No, yes.
My lord, because one view can be, which is probably not probably, in my opinion, definitely the correct view, that where this honorable court has interpreted a provision of the Constitution and made a declaration about a provision of the Constitution, then on the doctrine of legislative repeal, that constitutional interpretation can only be undone by an amendment to the Constitution.
And that brings us to the question that how could the Constitution be controlled by a sub-constitutional legislation? The Constitution is talking about a declaration, gives no time frame. Could we, through an act of Parliament, start adding things to the Constitution? We can't do that.
My lord, I would say that the declaration made by the Parliament is in consonance with Article 63(1)(h) of the Constitution, which provides a time frame for the kind of offences which will fall under F.
Because that involves conviction, that's a criminal case. But if you look at 63P, 1P or whatever it is, the P, the last one.
Yes, madam.
The Constitution itself allows that through an act of Parliament you can regulate this provision. And wherever it's so required, it's given.
So, just taking it a little more, suppose, let's imagine Samiullah Baloch was not decided, and we are deciding it today.
My lord.
Just for the sake of, to take the argument a bit forward, and let's assume everyone agrees with me And we say since 62(1)(f) does not provide a time limitation for disqualification, therefore let us be guided by other provisions of the Constitution, including 63(1)(h) and (g), where it provides for treason, 5-year disqualification. So let this disqualification be for 5 years. Is this sound reasoning or not?
My lord, it is, because your lordship is then virtually interpreting the two provisions together. When your lordship interprets...
So at the end of the day, it depends on what is in my mind. Are you understanding?
Yes, my lord.
Is the Constitution so malleable that I can do whatever I want to with it?
My lord, if 63(1)(h) was not there, let us assume there was only 62(1)(f), and if the 18th Amendment had not added the words which have been added, which is declaration to the contrary by a court of law, then 62(1)(f) would have been a provision which really provided no timeline. And if a person was declared not to be qualified under 62(1)(f), then the question would be for how long? My lord, the question can be for that term that he has been elected, or he can be re-elected immediately. My lord, for instance, the only other constitution that I have been come across which is a provision similar to that of Pakistan, where you cannot be elected to the parliament if you are the citizen or have acquired the citizenship of another country, is that of Australia. And the Australian High Court has dealt with this issue. No other constitution that I am aware of deals with.
American Constitution, you have to be an American.
You have to be an American citizen, but it does not say like our, my lord, 63(1)(c) says, or acquires the citizenship of a foreign state. So a dual citizenship over here disqualifies. In the Australian Constitution also, a dual citizenship disqualified. But the lordships over there have taken the view that if the person then steps down, abandons that citizenship, he can come back in tomorrow again. And there they have also taken the view that if he has applied for his citizenship to be renounced, then the constitution of our country will not be contingent on the delay or speed of the legal processes in another country. He has done the best he can, and therefore they have said he can continue to be in office.
Why were you disqualified?
My lord?
Why have you been disqualified?
From
The petitioner.
the petitioner.
Yes.
Petitioner was
Your client.
My lord, my client, yes, I was coming to that. My lord, he has been disqualified on the ground that he had created a trust for the property called Hyde House, and his defense was that Hyde House was a trust. The
misdeclaration in the nomination form, is that the allegation?
Yes, but his case was that there was no misdeclaration.
No, that's a different thing. I just want to know what was the reason.
So in all these cases, if you look at all these cases that were where 62(1)(f) was invoked, the misdemeanor is misdeclaration, or maybe they have not given misdeclaration. Generically would be it, and misdeclaration in the worst form taken could be brought into H. Worst form, moral कहीं हो सकता है innocently भी हो, लेकिन चलें worst form में ले लें, it is moral turpitude, and that provides for 2 years plus 5 years, so that's 7 years. So even if suppose a person did not get convicted because there was no case filed, worst to worst, if the case was there, he would be out in 7 years. So 7 years period could be easily read into the F clause, because that's the only natural corollary. I mean, it doesn't make sense otherwise.
Yes, my lord. And again,
would there be any incident coming out of F which will go out of H?
My lord,
मतलब आपने नई केस बनाया, सपोज मिसडिक्लेरेशन हुई, उसके खिलाफ किसी ने कोई क्रिमिनल केस ही नहीं किया, अगर हो जाता तो वो 2 साल वो होता और फिर उसके बाद 5 साल होता, यही है ना? Is there any situation in F which would go outside H?
My lord, not that I can think of. No.
Do you think the words in F, it says, it doesn't end by a contrary by a court, it says court of law.
My lord, yes.
Is a court of law different from a constitutional court? Because it could have stopped at the word court. So I just want to know, does it, the of law add anything or doesn't add anything?
My lord, of law adds in the sense that probably the returning officer will not have this power.
The returning officer is not a court. I'm
Yes,
just thinking
it is
in
not.
terms of Section 9 courts under the CPC. Are these court of law Section 9 courts or court of law? Because it should have said, it could have ended by saying by any court.
My lord, over here,
Are we distinguishing between the constitutional court and a civil court of competent jurisdiction, or we are not? It's meaningless, irrelevant.
this honorable court and your lordship yourself have held that over here the word court of law means a court of plenary jurisdiction. In Panama 1, which was not subsequently followed in Panama 3, this honorable
What do
court
you mean by Panama 1 and
Panama 1, my lord, was the first case which was decided 3-2, and Mr. Justice Aijaz Afzal Khan, writing for the majority, said that court over here means a court of plenary jurisdiction.
Meaning Section 9 court.
Section 9 court, a court which will take evidence, which will examine the issues where a trial takes place.
Or it could be civil or criminal.
He doesn't make that distinction. And I would submit that if your lordship have to,
Then how did that view change?
without mentioning what they have done in Panama 2 and Panama 3,
Is it referred to Panama 1 and Panama 2 and 3, this aspect?
no, my lord. Your lordship notices that in your lordship's judgment in Sheikh Rashid's case.
Actually, that was not a judgment, it raised a number of questions.
Yes, it raised a number of questions.
Yes.
But your lordship will see that even after Samiullah Baloch, different tests have been applied. The author judge of Samiullah Baloch was also the Chief Justice of Pakistan in Faisal Wabda's case, and has taken a different view without any reference to Samiullah Baloch.
Where is that view?
My lord, that is reported.
The repentance was that he did not contest the elections. So there was a repentance from.
My lord, that is Muhammad Faisal Wabda versus Election Commission of Pakistan and others.
PLD kya?
My lord, this is 2023 SCMR 370. My lord, 370. My lord, I have put these cases together in a bundle for ease of reference of your lordship. And this would,
देखिए या और भी
sir,
मैंने कहा और पैसे जाया करवाएं आपके
सर, ये आपके जो 62(1)(f पे जजमेंट्स हैं,
नहीं, ये पहले बताएं ये वाला केस
yes sir, it is the last tab. It is tab 20.
You're a member of this.
Yes.
My lord is one of the members.
Yes, his lordship is one of the members.
Said it as if it was something wrong.
Can you read the relevant portion?
My lord, yes, paragraph 4, it's a 2-page judgment really.
ji.
Paragraph 4, page 373. The petitioner states before the court that he regrets his claim of renunciation of the US nationality at the time of filing his nomination papers for the election of NA 249 Karachi on 7/6/2018. He further states he had then initiated a process for such renunciation, but the certificate of loss of nationality of the US was issued to him on 25th June 2018. He admitted that he was disqualified from contesting the election under Article 61(3)(1)(c) of the Constitution on the date when he had filed his nomination papers for the election of NA 249 Karachi, and that his affidavit filed in with the nomination paper thus contained an erroneous statement which he regrets. In order to demonstrate his good faith in remorse for his mistake, he undertakes that he will resign from the office of the member of the Senate to which he was elected. In view of the said statement and undertaking of the petitioner, we are of the opinion that we need not proceed further in the matter in the peculiar facts and circumstances of the case. And if your lordship may see the last sentence, which is the last 3 lines, it is clarified that the petitioner shall not be considered disqualified in any subsequent election on the basis of the instant.
The repentance is that period, that particular election.
Yes.
And so, but this is after he enjoyed the full tenure of the Senate.
Yes. Yes, and then he resigned. He
But
resigned.
एक चीज देखिए, Samiullah Baloch में paragraph 6 में the concept of repentance is mentioned,
Yes, my lord.
but I don't find a finding on it then.
No, there is
Argument of counsel finds mention on repentance.
My lord, yes.
But then it is, though the judgment talks about Islamic injunctions, this concept is not discussed unless I've missed it.
No, it is not discussed, my lord. That judgment is also on tab 7 of this very bundle.
So are you repentant?
So, Mr. Makhdoom, we could look at it like this, you see.
Are you repentant or you claim you've done no wrong?
My lord,
At the moment, you can only be repentant because your case is over.
my case is over, yes.
I presume you are repentant.
So, one reconciliation.
Reluctantly repentant.
My lord, his case was that I made no misdeclaration.
वो तो बात खत्म
My
हो गई
children had declared
वो
it
तो हम रिव्यू
as
करने
their
में बैठ
property.
जाएंगे वो तो फिर हम रिव्यू करने बैठ
ठीक है,
जाएंगे जजमेंट
So one reconciliation of 62(1)(f with H could be that if there is a misdemeanor of misdeclaration and no criminal case is made out, then he just misses out on the election and the matter comes to an end.
Yes.
But if you want to take it further and you file a case against him which is criminal, then H kicks in and you go through a conviction and 5 years. So there's a 7-year period there and there's an election period here. Because why didn't you not book him in any criminal case? Because you could do that. For any misdemeanor, you could have done that. If you don't let him go and you don't take criminal proceedings, then there has to be some mechanism, because if you take criminal proceedings, the mechanism is 7 years. But if you do not take criminal proceedings, then there must be some way out also. Because it's short of that, because nobody bothered to take the person on for that misdemeanor. So, I mean, that's one
Mr.
issue.
Makhdoom Ali Khan, but I think, can we go back to Faisal Wavda's case, please?
My lord, yes.
You said Samula is not mentioned. Samula is mentioned there.
It's mentioned. No,
ये जरा उससे पहला वाला पढ़ने, therefore.
बिल्कुल उस पैराग्राफ में mentioned है. It's mentioned but not followed because Islamabad High
Just पढ़ दें जरा सा. Therefore, it was concluded.
My lord, उससे अगर जरा ऊपर आप देख लें, the Islamabad High Court found that the petitioner was disqualified pursuant to the case reported as Speaker National Assembly of Pakistan versus Habib Akram for submitting a false affidavit, hence no declaration was required. Therefore, it was concluded that the consequences given in case reported as Samiullah Baloch and others versus Abdul Karim Noshirwani would follow by finding that a formal declaration by a court of law was not required to disqualify the petitioner under Article 62(1)(f) of the Constitution. The impugned judgment has in its para 11, 12 and 13 therefore misconstrued both Habib Akram and the Samiullah Baloch case. So they say it's been misconstrued and resultantly the impugned judgment is legally not sustainable.
How do you reconcile the two? This judgment and Samiullah Baloch?
My lord, if Samiullah Baloch was...
No, how do you reconcile the same two judgments by the learned same judge?
My lord, my submission is that if Samiullah Baloch was strictly followed, there was no way out but to disqualify Mr. Faisal Wavda and Islamabad High Court. For life, because Islamabad High Court had correctly decided the case.
He will be disqualified because of his corrupt practices.
Who, my lord?
The person who gives false statement.
Yes, my lord.
Corrupt practice defined in section 167 of the election laws.
My lord, yes.
But for that declaration, there must be criminal proceedings as provided in section 174.
Yes,
penalty for corruption or corrupt practices. उनको सजा होनी चाहिए कोर्ट से.
जी.
Court means criminal court.
Your lordship is
When there is
absolutely
no
right.
declaration from the court, can person be still called as a corrupt practice?
My lord, that is my submission, that 62(1)(f), the declaration which they're thinking about is the declaration under now the Election Act 2017, previously the Representation of People Act 1976, and the words used over there were
false statement and false declaration.
Yes.
So
And-
punishment for punishment, the court, criminal court,
Yes.
there must be a fair trial. Article 10A. Thereafter, if the court declares that the person has committed an act of corrupt
and that
practices,
is why your lordship will have to read 62(1)(f).
once that declaration is made, then under 62, if somebody shows at the time of submission of papers that this person is disqualified, is not qualified to be elected, his papers can be rejected. Whether in 62, period of disqualification can be made or not.
My lord, my humble submission is...
Are you also in this case, Mr. Mohammed? Yes. Are you also in this case?
My lord, I'm assisting Mr. Makhdoom Ali Khan. It's the same matter, my lord.
Okay, sorry.
I was counsel in...
We wanted to hear the other version as well. Because all of you seem to be on the same side in a way. So we wanted better articulation of the contrary viewpoint. Who would canvass that viewpoint? Anyone in the court who will canvass the contrary viewpoint with some level of seriousness.
Except Sana Baloch, everyone.
Sir, if you allow me just...
No, आप ऐसे जी. Anyone in this courtroom who wants to canvass the contrary viewpoint with a level of seriousness, we would like to hear, because you're an attorney general and most of them are just saying what you are on the same side.
My lord, I would like to submit.
कौन बोल रहा है?
From Lahore. Khurram Raza from Lahore, my lord.
Okay, then you please make yourself attend here. We don't want to hear important cases on video link. If you are serious about this case, come to Islamabad.
My lord, I will.
Someone who has the opposite viewpoint, senior counsel, Mr. Makhdum Ali Khan.
My lord,
The contrary viewpoint.
I think all the respondents.
Where is Mr. Shoaib Shaheen? He was here in the morning. Would he be canvassing the contrary viewpoint? Shoaib Shaheen साहब चले गए? अच्छा.
Mr. Babar Awans supported the lifetime ban in the Samuel Baloch case, so he might be a
कौन बोल रहा है? आप किस point? Mr. Qayyum,
Mr. Babar Awan.
No. What about yourself? What about yourself? What about yourself? Which view are you supporting? Lifetime ban?
Lord, I am supporting the law. I am against lifetime ban.
अच्छा, आपके साथ जो खड़े हैं वो क्या कहते हैं?
वो अपोज कर रहे हैं.
तो आप आइए जरा इस्लामाबाद, जरा अपनी हमें दीदार कराइए. We don't want to miss any valuable word uttered by you. So please be here. We will now be adjourning this case, and we would like to maybe we appoint some person from the other side, if we can say. आप
बल्कि अगर आपको कोई और सपोर्ट कर रहा है उसको भी साथ लेके आए लाहौर से.
बस भर के लेंगे.
My lord, there is
नंबर में कौन है केस में? जो सुबह का केस था, ये सैयद असगर हुसैन सब्जवारी. ये केस है काशिफ महमूद का. आप किस पॉइंट ऑफ व्यू को सपोर्ट कर रहे हैं? क्योंकि ये आपने सुबह का केस, ये इशू है आपके केस में. आप लाइफ टाइम बैन सपोर्ट कर रहे हैं या नहीं?
नहीं जी, मैं तो ये कहता हूँ कि there is a
नहीं, सिंपल बता दें. लाइफ टाइम बैन और 5 year बैन और नो बैन? लाइफ टाइम बैन. सो माशाल्लाह आप खुद हैं, तो आप आते ना सामने, हम आप बार बार पूछ रहे हैं. नहीं देखें, हमें मावनत चाहिए ना, कि अच्छी बात है कि आप माशाल्लाह सीनियर वकील. हम भी वर लुकिंग फॉर सम सीनियर काउंसिल टू कैनवस द अदर पॉइंट ऑफ व्यू एज वेल, सो वी कैन अंडरस्टैंड इट प्रॉपर्ली. खैर, आपने सारी बातें तो सुन ली. आप बैठे हुए थे ना सुबह से? नहीं सुन ली ना सारी बातें. हम आज अजर्न करेंगे. अब तो 3 बज गए, तो ये लोग भी आ जाएं. शायद इनके लिए कल मुश्किल हो आना, परसों पे रख लेते हैं फिर ये केस. ठीक है. और अगर आप कोई एनीवन कैन सपोर्ट, आप किसका नाम तजवीज करें जिसको हम माइकस बना दें, क्योंकि दूसरा कैनवस करे व्यू पॉइंट. माइकस तो खैर न्यूट्रल होते हैं, मगर क्योंकि वी हैव द सीनियर काउंसिल हियर ऑलरेडी. द प्रेसिडेंट इज हियर, मिस्टर मखदूम अली खान इज हियर, एंड सॉर्ट ऑफ नंबर ऑफ अदर अटॉर्नी जनरल इज हियर. आप भी इधर हो. फैसल सिद्दीकी साहब हो सकते हैं.
किसी केस में तो अहमद या सलाउद्दीन.
case, Mr. Munir Malik was amicus.
He was amicus then.
We saw these. There were a number of Mr. Asma Jahangir was there.
Malik Sahib was amicus then. Samiullah Baloch.
Whether he will be, how well he is.
Review links
In Samiullah Baloch.
No, but I thought the respondents would be opposing this. The respondents in these cases would not be opposing would be supporting the lifetime ban.
Mr. Maktoum Ali Khan, you won everyone over.
All the respondents are now against the lifetime ban. I don't understand. So who?
In fact, my lord, the opposing side, they were initially were of the fact that it must be a lifetime. Prior to that, in 2018, we are those who are making out that we should not be given a lifetime. We are for the 5 years. So only one thing is this, my lord, the whole scenario, I want to just add one thing. That is that a declaration and the conviction, these are the two words which are very necessary to be adjudicated by this honorable court. The one thing is this, that the conviction which has been maintained by any criminal court, that has to be given a kind of the seal of legality may be coming from the Election Commission of Pakistan, because in that the original trial court has to send the record of that case to the commission, so that afterwards that can become into the force through the legality that next time ab ek aadmi ko saza ho gayi, ek aadmi ko for 2 years under 199 200 of the RUPA or the now present Election Act, or under 471, that conviction will thereafter be sent to by that court to the commission, Election Commission. The Election Commission will then going to file a complaint against the
मुख्तसर बात करें ना, आप अपनी तकरीर कर रहे हैं, कुछ बता रहे हैं कि आप कहना चाहते हैं।
62F की जो प्रोसीडिंग स्टार्ट होंगी वो इलेक्शन कमीशन की कंप्लेंट से स्टार्ट होंगी। मैं ये कहना चाहता हूँ।
इसका फायदा क्या इस बात करने का?
ये फायदा है कि
बगैर सजा के आप कहते हैं कि बगैर कोर्ट के कन्विक्शन के आप कहते हैं कि डिक्लेयर किसी को नहीं किया जा सकता।
नहीं सर, नहीं, कोर्ट जो इलेक्शन कमीशन को फिर भेजेगी और वहां से कंप्लेंट
इलेक्शन कमीशन की कंप्लेंट पे हो सकता है, ये आप कह रहे हैं।
62(1)(f) के ऊपर
पोस्ट कन्विक्शन।
जी सर।
सनाउल्लाह बलूच साहब, ये देखें बहुत पेचीदा आईनी कानूनी मसला है। यकीनन आप पार्लिमानी मेंबर रहे और अच्छी तरह से आइन को समझते हैं, मगर हम आपको मौका देते हैं कि अगर आप कोई वकील करना चाहें, क्योंकि आप सपोर्ट कर रहे हैं ना लाइफ टाइम बैन को, तो क्योंकि ये इसमें ज़रा हमें तशरीह करना होगी, तो ज़रा यकीनन आपकी महारत है, पार्लिमानी महारत, मगर ये ज़रा बहुत टेक्निकल इश्यूज भी हैं, तो हम आपको एक मौका भी देते हैं। अगर आप किसी वकील को करना चाहें, आपकी मर्जी है, तो आप कर लीजिए। ठीक है, हम आपकी बात हम नोट कर ली, मगर वो देखें फिर हमने जितने बहुत सारी आर्गुमेंट डिस्कशंस यकीनन आपने सुने होंगे, तो आप अगर कोई करना चाहे वकील हम कर लें, तो हम परसों पे फिर इसको रखते हैं, परसों केस 11:30 बजे।
मैं सर इसमें
first application Arrow has rejected my nomination papers on the ground that disqualification is perpetual and for life.
इसीलिए तो हम चाह रहे थे ना, once and for all सुप्रीम कोर्ट बैठ करके ये तायुन कर ले, बिकॉज एक आरो कुछ करेगा, दूसरा आरो कुछ करेगा। अच्छा मिस्टर मखदूम अली खान, वन अदर इशू,
My lord.
one is, you know, you win all or lose all. One is the middle way. The middle way is that Al-Samrez was the law undid its effect. Can we have the list of those cases where a non-obstante clause, irrespective of anything held in a judgment, and they were sustained? Because that could be the middle way, that we don't touch the judgment, but now that the law has come, it occupies the legislative domain. This is one aspect. The other aspect which has not been touched upon is that we have only read the constitutional provisions so far. Most of these cases deal with the earlier election laws, which was ROPA, Representation of the People's Act 1976. Did that law or the Election Act of 2017 provide any term for disqualification, or it simply reproduces the language of the Constitution? Because I'm familiar with ROPA, I'm not so familiar with the subsequent enactment of 2017. So if you can consider those as well, that does the law say anything at all? And the third thing which I want you to attend to is did either law, ROPA or the Election Act of 2017, prescribe a period of disqualification which was not mentioned in either 62 or 63? Are you clear with the queries?
Yes, my lord. Yes, my lord.
And these, for everyone else as well, these queries they can attend to.
My lord,
and I will request any of my colleagues, if they want to put a particular query, that you all can come prepared on that.
My lord, with one request and leave of your lordship.
ये डॉक्ट्रिन ऑफ लेजिस्लेटिव रिपील के ऊपर आप थोड़ा
जी सर, उस पे यही मैं रिक्वेस्ट करने लगा था चीफ जस्टिस साहब से कि those bundles are also ready, that list is ready. Your lordship will have to allow me to file a couple of more bundles.
मैं समझा नहीं.
You're wasting a lot of paper.
नहीं, which bundles?
वो सर लिस्ट ऑफ केस लॉ मैंने बनाई हुई है.
ये सबके लिए बना दें.
जी सबके नहीं है, अभी भी सबके
नहीं.
हमने
आपको नैब केस में भी कहा था कि iPads दे दें हमें. सेव पेपर.
My lord, इस इशू पे एक्चुअली मैंने ऑलरेडी पेपर बुक्स बना ली हैं. वो वैलिडेटिंग जो क्यूरेटिव लेजिस्लेशन के ऊपर केस लॉ है मैंने ऑलरेडी.
तो आपको चले एक दिन का मौका मिल रहा है जी. अगर कोई और क्वेश्चन एनी ऑफ माय colleagues want to ask, no, not you, I'm saying, I'm requesting my colleagues.
There is a very serious question of
ready with these queries.
Briefly, my lord, the citations are already there in the CMA which I have filed, but these will be submitted separately as well.
Please attend to the question of repentance which Samula Baloch specifically records.
My lord, yes.
तो ये जरा आप वो भी आप जरूर देख लीजिए.
My lord, एक बड़ा सीरियस क्वेश्चन ऑफ लॉ है इन्हीं अपील्स में जो जिस पे I would request my lords to also adjudicate, and that is what is the effect of suspension of sentence of a convicted person. Is it
one thing we've already noted in our original order, which was a 3-member bench order. Of course, if my colleagues want to add to it, that we will stay clear of criminal cases, pendency. We are just going to restrict on qualification and disqualification because elections are.
इस केस से तो नहीं ताल्लुक.
My lord, वो judgment उसके अपील में मैं आया हूँ और वो sustain हो नहीं सकती because that judgment is in violation of a number of judgments of the Supreme Court. वो judgment basically उसका effect ये है.
हम principle of law तयन करना चाह रहे हैं. Individual cases हो सकता है उनको अलग कर दें, फिर सुने, छोटी बेंचेस सुने. ये 7-member बेंच अगर सुनने बैठ जाए तो पूरे इलेक्शन खत्म हो जाएगा. सुनते
सिर्फ प्रिंसिपल की मैं बात कर रहा हूं. वो उन्होंने रिडंडेंट कर दिया है आर्टिकल 63(1)H को, जो हमने अभी
बात में सुन लेंगे. आपने
जो कंसाइज स्टेटमेंट दिया, नंबर क्या उनका?
माय लॉर्ड, उसका मेरा नंबर है जी 8, CMA नंबर 8 है माय लॉर्ड. और इस पे केस लॉ भी माय लॉर्ड मैंने सारा जो मैंने कोट किया हुआ, मैंने उसकी पेपर बुक्स भी बनाई हैं माय लॉर्ड.
आपकी CMA कौन सी?
Mine is 6, my lord.
So what we do today, we'll observe loudly, and that I'm sure will be recorded. If anyone wants to canvass the contrary point of view, not to come and make a speech, but attend to the constitutional provisions and the law, we are ready to hear it. The contrary view being that it's a lifetime ban. So because most of you are in support of a 5-year ban or no ban at all. So that offer is open to everybody. If we consider, we will appoint amicus as well, but at short notice, whether they can render even that assistance or not, because this has to be wrapped up very quickly one way or the other, because every returning officer should not be left confused what he has to do. I'm sure you all agree to that extent. Whatever it is, it should happen once and for all.
And my lord, my CMA number 1 for stay is fixed today. Regarding the RO in civil appeal number 1946/2023,
been disqualified.
My lord, RO has held that he is disqualified for life, regardless of section 232(2) and regardless of orders passed by my lord.
नहीं तो हम देख लेंगे ना. अभी हम
अपील में जाएंगे ना.
अपील तो कर लेना, अपनी राइट्स ऑफ.
As an abandoned caution, we have.
हाँ तो वो कर लीजिए ना. पता नहीं हम किस तरफ फैसला करें. अगर हमने आपके फेवर हो गया तो उसका इफेक्ट हो जाएगा ऑटोमेटिकली. ठीक है.
had drawn your attention to the 4 points which Ishaq Hakwani's case the court had left open with regards to which court would it be to give the declaration, the procedure to be followed, the standard of proof and the locus standi. It is PLD 2015 Supreme Court 275. At page 283, these 4 issues are identified but were left unanswered. So if my lords, and this is also for posterity because this declaration of law, now we are looking at the time limit which is to be applied to this declaration of law, but how this declaration is to in fact be given is also something very important. 2015 Supreme Court, PLD 2015 Supreme Court 275, Ishaq Hakwani versus Mia Nawaz Sharif, and page 283.
I didn't do it in 9:30.
Paragraph 4.
In a judgment, my lord, in Roshan Ali Brero's case, your lordship has also raised that similar question while dissenting, my lord. That question is still parked, my lord. Which one? It is appeal to the future, my lord.
2019 as CMR.
Yes, this is 2019. This is, my lord, 2019 as CMR 1939.
1939. So appeal to the future. Are we the future?
Yes. So now is a good time, sir.
चलिए इसमें लिखें फिर.
या आपने भी अपील टू द फ्यूचर कर दे.
अच्छा हाँ इसमें लिखिए CPLA number 2680/2023. The point raised in this petition are the same as are being considered in the cases in Civil Appeal 981/2018 and other cases fixed before the 7-member bench. Accordingly, this case to be fixed along with the said cases as well. Full stop. The number. अच्छा ये हमें एक चीज भी बता दीजिएगा ये हमें because there should not be created an impression which unfortunately we cannot control social media or even media, but for accuracy's sake, who is contesting which political party, so let it not be perceived as this is for a political party or against a political party. We are only concerned with the constitutionality and the legality of the matter. So I really don't know these names, whether they're independent candidates or their things. So if someone can give us a list of who's where, so that would be helpful and may dispel the notion that it is for a particular cause, which is not our concern in the least. क्या लिखा है? हाँ इसमें लिखिए the learned attorney general and the advocate generals of the provinces state that they support the constitutionality and legality of section 232 within bracket 2 of the Elections Act. There is an S, Elections Act 2017. Full stop. A number of petitioners oppose कौन कर रहा है? आप. Most of the petitioners most of the council representing petitioners appellants applicants support the contention of the learned attorney general and the advocate generals, whereas आपका नाम लिख दे in CMA CP 684 और कौन अपोज कर रहे हैं आप?
880 CA 880.
नाम अपना बताएं. नाम बताइए.
खुरम रजा मेलो.
मिस्टर खुरम रजा and Mr. Khuram Raza in
CA 880 /2015
states that the lifetime it is a lifetime ban. अच्छा, सब्जारी साहब भी का नाम पहले लिख दें, सीनियर काउंसिल है ना, सीनियर काउंसिल का पहले नाम लिख दें, सब कैनवस द कॉन्ट्री व्यू पॉइंट दैट इट इज अ लाइफ टाइम बैन, फुल स्टॉप. A number of council are appearing from other stations through video link, and they are requested that in view of the constitutional importance of the matter, it would be better if they are in attendance at Islamabad so that their submissions can be properly heard and understood. Full stop. We also welcome any senior counsel who wishes to assist this court to do so with precise constitutional and legal submissions supported by applicable case law. लगता है कि अगर हम कोई माइकस अपॉइंट करें शॉर्ट नोटिस पे, पता नहीं, it will be fair to a Micus or not. Can you suggest a name that we can appoint and who's available at Islamabad or Pindi? कलवे हसन साहब एक सीनियर वकील हैं, और कोई और अगर आपको कोई
इस्लामाबाद दूसरा आना चाहिए ना.
आई डोंट नो
फॉर्मर जज ऑफ हाई कोर्ट लाहौर,
या मौजूद कोई इस्लामाबाद पे, अब हम उनको लाहौर से बुलाएं किसी को.
इस्लामाबाद में होते हैं.
कौन?
पिंडी में होते हैं.
कौन?
मौलवी अनवारुल हक साहब.
हाँ,
मौलवी अनवारुल हक साहब.
ठीक है, इन दो को करने हैं.
My lord, he is not enjoying very good health these days. He's having issues with his health lately, my lord. Maulvi Anwarul Haq.
नहीं, हम ऐसा करें, हो सकता है हम अपॉइंट कर लें जरा, बिकॉज वो कह रहे हैं उनकी तबीयत ठीक नहीं है. बट एनीवेज इफ समवन वांट्स टू कम एंड असिस्ट ऑन अ लीगल पॉइंट, इवन इफ दे नॉट पार्टीज, दे मे कम एंड डू सो. सनाउल्लाह साहब को हमने ऑलरेडी कह दिया. मिस्टर सनाउल्लाह बलोच states that he represents his brother Samiullah Baloch and supports a lifetime ban. However, since since we are adjourning the matter, he is granted an opportunity to engage counsel if he elects to do so, or be properly authorized by his brother. ठीक, adjourn to परसों की तारीख दे दें, जुमेरात की at 11:30. ठीक है. अच्छा, we are planning to conclude on 11 January. So that be precise as far as possible, and those questions we will not reproduce in the thing. We will just leave it like that. Anything anyone wants to add?
My lord, only this, that if your lordship is willing to consider as far as Karachi, then Mr. Faisal Siddiqui can be a choice.
That's the name that we're thinking.
Yes, Mr. Salahuddin Ahmed, Faisal Siddiqui,
Salahuddin Ahmed, Mr. Faisal
Unless they're in one of these cases.
Ji.
So we will
check with them.
We will just we may add some amicus.